Everyone, my name is Jazzy and I'm going to be kicking off Group B's presentation for the case number 320CV00317 MMD-CSD, the United States District Court of Nevada for behalf of the plaintiff Eufemia Guillen versus the defendants BJCR LLC. As mentioned, the plaintiff and defendants of this case are Eufemia Guillen as the plaintiff and Chuck and Barry, part of the BJCR LLC Corporation, for the defendants. To give a little bit background knowledge on this case, it began when Ms. Guillen, the plaintiff, alleged that she worked for the defendants at the Comfort Inn in Elko, Nevada as a kitchen and breakfast room worker for approximately 16 years before she was constructively discharged on March 19, 2019. The defendant also owned and managed the Days Inn and Rodeway Inn in Elko, Nevada, and on occasion they would send Ms. Guillen to run errands or to work at the Days Inn or Rodeway Inn. Ms. Guillen alleges a pattern of sexual harassment and assault, including rape, by the defendants Chuck and Barry between 2018 and 2019. She averts there is video evidence documenting some of these instances of harassment and assault. Ms. Guillen further alleges she was warned not to say anything about the abuse because she was a wetback and would not be believed, and she was also threatened with deportation to Mexico. She asserts claims under the federal law of discrimination and hostile work environment based on race under 42 U.S.C. 1981, as well as state law claims of assault, battery, false imprisonment, intentional infliction of emotional distress, negligent infliction of emotional distress, negligent training, supervision and retention, tortious constructive discharge, aiding and abetting, and concert of action, and a statutory claim under NRS 41.690. After hearing about and learning some of the background of Ms. Guillen and the federal claims, state claims, as well as the incidents that led to these claims, the retaliation of these claims were that the defendant requested the plaintiff's immigration documents from the Department of USCIS as a deterrent against continuing the case. Then, the plaintiff then sought a protective order on all her immigration documents. The involvement of the Department of USCIS was the plaintiff and Ms. Guillen highlighted her eligibility for a U visa, which offers temporary non-immigrant status to victims of certain crimes, including sexual assault. The U visa grants victims and families 4 years of non-immigrant status with potential for lawful permanent resident status after 3 years. Ms. Guillen argues that the requested access to all immigration documents is overboard and disproportionate to case needs. After hearing about the federal claims, the state claims, and the retaliation for the defendant, the constitutional question is right to due process in regards to the Fourth Amendment, protests against unreasonable searches and seizures, and relevant to the issue of document access in the case. The court rulings were that the defendant's motion to compel was denied because of access to irrelevant documents deemed unnecessary. The plaintiff's motion for protective order was granted. The plaintiff's motion for protective order was granted for non-U visa documents. However, the outcome for U visa documents was denied as moot, meaning no protection order needed.
How does this case potentially impact similar cases or legal matters when dealing with immigration? The primary stakeholders would be the plaintiff and the defendant. The secondary stakeholders would be business managers, owners, employees, and immigrants. Managers and owners will need to be wary of employees knowing their rights and fighting back against abuse despite any fear of deportation or criminal charges regarding their immigration status. Immigrant employees may be emboldened to use their right to resist abuse at the workplace with things like the U visa. Pause to answer this question. If the court ruled against Euphemia Guillen, how do you think it would affect other immigrants who are victims of similar crimes?
Two cases the judge has used to come to the outcome of this case are Rivera v. Nipkow, Inc. In Rivera v. Nipkow, the plaintiff, a female immigrant, alleged disparate impact discrimination based on national origin under Title VII of the Civil Rights Act and California Fair Employment and Housing Act. This case was used in the context in which both plaintiffs were immigrants who experienced discrimination, and in the case of Rivera v. Nipkow, similarly to our case, it was established that the immigrant status of the plaintiff should be protected, as this information could impact their immigration status, and undocumented immigrants might face criminal prosecution and deportation. The other case was Cazorla v. Coach Foods. In the case of Cazorla v. Coach Foods, the Fifth Circuit addresses the issue of whether information related to U visa applications, which offers temporary non-immigrant status to victims of certain offenses, including sexual assault, could be discovered during litigation. In the case of Cazorla v. Coach Foods, the plaintiffs were mostly Hispanic employees who alleged abuse at work, including sexual assault and harassment. This case was used as information regarding the U visa, but the plaintiff in the case Guillen v. BJCR is not in possession of the U visa document that the defendants were seeking through their motion to compel.
Pause to answer. Were there any particular legal arguments or evidence pieces presented in the case that stood out to you, and why?
All right. So, on our opinions, our group agrees with the outcome of this case, as we are in favor of the U visa. The U visa program is indeed a significant step towards providing a safe and just environment for immigrants who often face oppression and violence. It grants temporary non-immigrant status to victims of substantial physical or mental abuse resulting from certain offenses, including sexual assault, abusive sexual contact, extortion, and felonious assault. This program empowers migrants to voice their concerns against any harmful crimes committed against them, and it plays a crucial role in ensuring their safety and protection. It is important that we provide equal protection and justice to all individuals, regardless of their immigration status. It is also important that the immigration status of the plaintiff is protected, as the immigration status could potentially negatively affect future immigration, as well as the fact that people might feel reluctant to report issues like this due to the fear of facing criminal prosecution and deportation. The U visa program is an essential tool in achieving this goal and ensuring that immigrants are not marginalized and oppressed in any way. Now, we would like you to pause and think about what lessons you think businesses or individuals can learn from this case in terms of legal compliance or risk management.